unified approach. So why do all these laws go together, then? Sir Rupert Cross claimed that there was a single path to perception in such a way that the judge will begin using the linguistic and normal or, where necessary, scientific meaning of words in the general way of the law. If the court deems that this would generate an outrageous outcome, he might use any second interpretation that the phrases are interested in the possibility of bearing. The court might well read in words that he perceives simply implicit in the words contained in the law, and has limited potential to add, change, and dismiss words to prevent a clause from becoming incomprehensible, impractical, or ridiculous. In implementing those regulations, the court may call attention to a variety of aids and presumptions. But, this unified approach is centered on a literal approach, and it doesn't permit for a purposive approach. There seems to be a step to a purposive approach currently, while not all courts concur it should be used. Should there be one preferred rule? It would also be useful if there were one specific technique of statutory interpretation that has always been used for the cases. For now, it is completely up to each individual judge who decides the case to enforce whatever law or solution he chooses. Some judges may have recourse to a strict law, other judges may have recourse to a mischief rule or a new, purposeful approach. It makes it hard for attorneys to give advice on the interpretation of the contested judgment of a judge in the Act of Parliament. At times, the judge can agree to use the literal rule for one situation and the mischief rule in another case. It began in Lord Parker, who used the mischief rule in Smith v. Hughes and then used the literal rule in Fisher v. Abel. It may well be that this assumes that the judge will decide what the outcome of the trial is and then chooses a law that results in that result. In 1969, the Law Commission recommended that Parliament enact an Act of Parliament that would imply that the mischief rule had to be enforced in effect to facilitate the general statutory intent. But, this proposition was overlooked, even though Lord Scarman proposed a bill on the subject to the House of Lords in both 1980 and 1981. He was forced to abandon the plan for the very first time. The House of Lords opted for it for the second time, but the issue has never been presented to the House of Commons. There is a possibility that, even though there was an Act of Parliament, there will still be differences in the laws used by judges. It has been demonstrated in New Zealand, which has a statute that promotes implementation in the appropriate way to ensure that the purpose of the Act is accomplished. Although this would imply that this is achieved in every situation, one author pointed out it is often hard to find out which method was used, and all that is being said is that certain judges had been relatively consistent at occasions in using the method they choose. The purposive approach. That extends further than the mischief rule, that the courts aren't just trying to see what void was in the previous law, the courts are determining what they think the Parliament was supposed to achieve. Lord Denning was the founder of this approach in English law. His mentality toward more legislative interpretation is demonstrated because he said, in the case of Magger and St. Mellons v. Newport Corporation, 1950, we stay here just to find out and implement the intention of Parliament because we do it better by filling in the gaps and making any sense of the law than by making it available to damaging evaluation. Nevertheless, the judges in the House of Lords questioned his conduct as they considered the appeal in the trial. Lord Simons found Lord Denning's method a brazen usurpation of the statutory purpose under a thin veil of definition and pointed out that if a void is discovered, the solution resides in the amending act. Another judge, Lord Scarman, said, "When Parliament states one thing but intends another, it is not for the judiciary to amend it on the grounds of the traditional standards of the common law. In our community, the basic principle will certainly be appropriate. They are to be regulated not by the wishes of the Parliament, but also by the enactments of the Parliament." This statement demonstrates the problem of the purposive approach. Should the judges refuse to obey Parliament's clear language? How would they learn what the goals of the Parliament were? Opponents of the purposive approach argue that it is difficult to determine the purposes of the Parliament. Only the terms of the statute will reveal what the Parliament intended. Case example. Another illustration of the use of the purposive approach is the case of R. Quintavalle v. Secretary of State for Health, 2003. The House of Lords used the purposive approach in determining that species produced by cell nuclear replacement, CNR, had been identified as embryo in the Human Embryology and Fertilization Act 1990. Section 1(1)(a) of this act specifies that embryo is a living human embryo where fertilization is complete. The CNR was not feasible in 1990 when the act was passed, and the question is that fertilization is not used in the CNR. Lord Bingham said the following: "The duty of the court, inside the appropriate scope of definition, is to give consideration to the intent of the Parliament. Parliament could not have wanted to differentiate between embryos created by or without fertilization because it did not know the latter possibility. You can see why this goes beyond mischief rule. During the time of the Act, Parliament found the mistake, or legal gap, of the possibility of abuse of embryos produced by fertilization. That was the purpose of the Act. Parliament did not even know the difference in regards to the embryos of the CNR, they had not been created. As a result, the purposive approach is to ensure that the purpose of the Act is provided effect. The confusion theory just points at the void in the law at the time the Act was passed by the Parliament. The European approach. The purposive approach is favored by most countries in Europe when evaluating their own laws. It is the method introduced by the European Court of Justice in the interpretation of European law. The power of the European preference over the objective approach has influenced the English courts in two respects. First, they had to agree that the analytical method was the right one to use in coping with European law. Second, making use of the purposive approach to European law allows judges more used to it and is thus more applicable to English law.